Hi, everyone. I don't want to interrupt the conversation I see going on all over the room, but I'm going to interrupt it anyway. So welcome, everyone, to our third nonprofit lunch of the year here in March on sexual harassment. I wonder how we thought of this topic. It's, it's amazing. But somehow it seems to have resonated since we have a great crowd here and we have several hundred people on the phone joining us. So welcome to everyone on the phone. I'm Cindy Lewin. I'm a partner here at Venable in the nonprofit organizations practice. I joined in the fall after being in-house, like many of you, as general counsel most recently at AERP and before that at National Wildlife Federation and Volunteers of America. I was attracted to Venable because we have one of the largest, if not the largest, nonprofit practice in the country, both in terms of the number of clients and in terms of the number of lawyers who are really focused, our core group of lawyers who are really focused on representing nonprofits. But we also are so fortunate to have a number of lawyers who help us support those nonprofit clients. And we have two of those lawyers here today from our labor and employment group, Todd Horn and Jennifer Prasinski, and they have been incredibly helpful. They've saved the day for our nonprofit clients more often than I can count. They're on my speed dial. And that you have their bios in front of you, so I won't go through that other than to just say that Jennifer has spent the last 2 days doing training, harassment training, in a sort of factory setting where she had to train all 3 shifts. So she was starting at 5 a.m. the last 2 days. So she's very warmed up with her training. And Todd has been named Employment Lawyer of the Year in Baltimore. So we're very happy to have him from our Baltimore office. We have a lot to cover today, so we're going to save questions till the end. And I'll be quiet as the moderator. I think I had my main contribution when we had our planning call. And Jennifer and Todd were really committed to not just sort of marching through the black letter law of sexual harassment, because everybody knows that and everybody's already been to that seminar. So they really wanted to do hypotheticals so we could talk about how these cases play out real life on the ground. And they were like, let's talk about hypotheticals. And I was like, how about this. Whipped off about 10 in 5 minutes. They were like, wow, how are you doing this? And those of you, how'd you think of those? And those of you in the room were thinking, she didn't think of those. She just remembered those. So yeah, 20 years in-house. Anyway, with that, I'll just make 2 quick announcements. One is that you can get certified association executive credit for this if you're here in the room, and the information is in your packet. And just to preview our upcoming, our April lunch will be on a federal contracts and grants topic about what can go wrong after you get the award. You think winning the grant or contract was the be-all and end-all, but apparently not. And then in May, on May 17th, we're covering election year legal issues and opportunities for nonprofits. And since these days every year is an election year, I'm sure that will be popular. But with that, I will turn it over to Todd.
Hello, everybody. I firmly believe that the best way to learn something is to make a mistake, to endure the pain and humiliation of that mistake, and never repeat it. I believe the second best way to learn something is to watch others make mistakes, enjoy their pain, and then reap the dividends of their mistakes. Now, Jennifer and I and Cindy have been representing employers for a long time. So we have an enormous menu, an inventory of mistakes that other organizations have made, experiences, in case it's any of you all, so that we can share them with you. And perhaps if you are confronted with something like that, it will help sharpen your skills in how to deal with them. We talk about an extensive library. I've been doing this now for 30 years. And my very first case on my very first day at Venable in 1987 was a sex harassment case. I was thrown into representing an asphalt paving company who was being sued by a woman who worked as a traffic flagger, who insisted on wearing a bikini at work. Okay. I know what you're saying is, how can that be? How can that be? But I got to tell you, every month we get cases. We look at each other and say, how can that be? But it be. Okay, as I go through these scenarios, I'm going to be asking questions, but they are purely rhetorical to get you thinking. You will be so tempted to want to answer, but hold them off. We will save time at the end. So let's get started. Okay, picture this. You are a seasoned HR professional. One morning, a female employee comes into your office crying. You recognize her, but you don't really know her. She closes the door and says that her new boss, Mr. Smith, has been sexually harassing her. She sits down, she composes herself. You ask her what happened. She said, Mr. Smith has been harassing me in several ways. I'll start with the most recent one. This morning when we were coming to work, he treated me in a very chauvinistic, demeaning, sexually stereotyping way, and I was very offended. Next is, earlier this morning, he touched my shoulder, and it made me very uncomfortable. Anything else? Yes. Day before yesterday, he pried into my sex life with my fiancée. It was very offensive. Anything else? Yes. He subjects me to vulgar, obscene, and crude language. I just don't appreciate that. It's very bullying. Anything else? Yes. The last straw was 30 minutes ago. I caught him staring at me, and then he started talking about my skirt. So I came into here. You asked her, are there any witnesses? She says, no witnesses, just him and I. She begs you to do something about it, leaves the office, bawling, takes the rest of the day off. Question 1, has Mr. Smith sexually harassed her? Okay. Some nods, some curious looks. But do we have enough information to answer that question? What do you do next? Well, you summon him to your office, Mr. Smith, and confront him with the allegations and see what he says. So, you say, well, she said you demeaned her with gender stereotyping this morning. And he says, well, my parents taught me all my life to be very polite. And when I approach a door, I open it for them. And this morning, we approached the building at the same time. I opened the door and I said, ladies first. Okay. She said you touched her shoulder. He goes, I did. Later this morning, we were chatting, and I saw that there was this enormous stink bug crawling on her shoulder towards her neck, and I reached and flicked it off instinctively. So yes, I did. She said you pried into her sex life with her fiancé, and he goes, well, I'm not sure about that, but she did tell me that she was going to a couples resort retreat, and I asked her if she had a good time. She said that you subject her to vulgar language. It's crude and obscene, and he said, well, I'd been working on this stack of papers, this file, for days and days, and I was walking down the hall, and they slid and fell and scattered on the floor, and I said the F word. Said you stared at her and commented on her short skirt. He goes, well, she has a very important client meeting tomorrow, and I told her that the skirt she was wearing is too tight and too short, and she should consider something a little more appropriate for that meeting. Okay, so now, same question. Has she been sexually harassed? How do you answer that question when you are confronted with that as an HR professional? Who decides? Do you have a formula? Does the woman who's complaining, do her views have any impact? Well, I've got some good news and some bad news for you. The bad news is there is no computer program in which you could input this information, push a button, and spit out and get a yes or no, there has been harassment. The good news, though, is there are several factors you can evaluate to answer the question at hand. And the question is, would a reasonable person, which is all of you, conclude that the totality of the circumstances is offensive, gender-based, and severe and pervasive? Okay, can we go to the next slide, please? So, here are the factors we look at, and I'll briefly go over them, but let me tell you what you don't want to look at. You don't look at labels. They're completely unhelpful. And the complainer just used labels, remember? Offensive language, stereotypes, etc. They can be inflammatory, and they can divert your mind down an incorrect path. So just focus on the facts. The facts you look at involve the frequency of the conduct. Did this happen one time or every hour on the hour? What is the duration? Is this flicking a stink bug off the shoulder that just took a fraction of a second? Or is it a greeting, hug that lasts way too long? You know what I mean? Severity. Was it a risque joke or a gender-based slur? Was it a pat on the back or a pat on the rear? You know, you will evaluate the severity based upon the culture of your organization and your own common sense. Was it verbal or physical? Was it a crude joke or was it a grope? Did it interfere with the person's ability to do the job? Did they laugh it off or did it cause their performance to nosedive? Was it a supervisor that did this or a coworker? Generally speaking, if a supervisor is the alleged harasser, it is treated a little more seriously. And then you have to consider all of these things in the context of how they were presented to me. I mean, for example, she complained about prying into her sex life. He made it sound, yes, I asked her if she and her husband or her fiance had a good time, which is innocuous. But what if he said, hey, I hear you and your fiance were going to a resort. Did y'all have a good time? Huh? Yeah? You know, it's creepy. It's inappropriate. So you gotta factor that in too. So once you have all the facts from this list, it'll help you assess the question. Remember the first question I asked, has she been harassed? That's a trick question, okay? Because it's not binary. It's in most cases not yes or no. At the extremes, it is binary. But in most cases, it's gray. So I have invented a tool to help you assess whether or where it falls, whether or not it may be an issue. And I call it the 1 to 10 scale, okay? What you do is you take the totality of the circumstances, and we'll use this scale later, so it will come back and visit us, and you put it on a scale, okay? Number 1 is something that barely registers, but you may not want happening at your workplace, like a Taylor Swift calendar, okay? 10 is Harvey Weinstein stuff, okay? And then you've got the full spectrum in the middle. And it is going to be different for you and your organization. It's not going to be uniform. Okay, so that's how you do the, I don't want to say math because people hate math, they panic, but that's the formula you generally use. So, question, can one incident, even if it lasts only a few seconds, can that qualify? Is that enough on the spectrum to be a 10? In the eyes of the law, the answer is absolutely yes. One incident, if it's sufficiently severe, such as certain touchings or certain horrible slurs, can be enough to qualify as harassment. Okay, last question before I turn this back over. Did I give the complaining person a name? I have Jane written down here. So Jane, does it matter in filling out this formula whether or not Jane honestly believes that she's been harassed? In other words, she in her core being knows she's been harassed, but you look at all the factors and go, no, this is not harassment. Does that matter? In the eyes of the law, kind of, okay? If the person does not genuinely believe they've been harassed, you're not going to be liable, even if, in fact, she has been. The converse, in other words, the person both has to subjectively believe they're harassed and the objective facts have to suggest harassment. But, let me make this clear, from an HR, from a human relations standpoint, from an associate relations standpoint, the fact that she believes she's been harassed is a problem that needs to be addressed, even if, in fact, she hasn't. Because if you don't address claims somehow, and we'll talk about how to do that later, you are just asking for turmoil. You're asking to make your workplace a living hell because you risk sabotage, rumor mongering, backstabbing, all kinds of things that are just disruptive. So even if it doesn't rise to the level of unlawful harassment or a violation of your policy, you're going to want to address it, and we will chat about that later.
Good afternoon, everybody. So Our next slide is, so just to give you a recap, I know some of you are HR professionals or deal with the HR function. We're going to be talking about the smiling subordinate and the unwelcome requirement. So just to recap, in order for it to be unlawful harassment under Title VII, you have to hit 4 requirements. 1, the conduct has to be offensive. 2, the conduct has to be unwelcome. It has to be based on a protected, legally protected characteristic, sex, and it has to create either a hostile work environment or a term or condition of your employment. This one, we're going to focus on the welcome requirement, right? So imagine you're an HR professional. You're doing a 360 performance evaluation of your employee, Tim. Tim's a supervisor. He's got 2 subordinates, right? He's got a team of 2. He's got Jeff and he's got Mark. So as part of your 360 evaluation, you're talking to Jeff about Tim. And Jeff is telling you, Tim is a great supervisor. He's got this great collaborative team. We all work together so well. Jeff says, you know, in part, I think the reason why we work together so well is because Tim's got this great sense of humor. He tells these jokes every single Monday morning. They are hysterical. Let me tell you, these jokes are filthy. They are of the 50 Shades of Grey variety. I don't want to tell you the jokes because I might offend you, but let me tell you, they are hysterical, he says. And Jeff is telling you, we love these jokes, Mark loves these jokes, and Tim loves these jokes, and we just sit around and we laugh and we laugh and we laugh. We think it's great. And that Mark, he is quite a jokester too. You should hear the jokes he tells. They're even filthier than the one Tim tells. So Jeff tells you, you know what? I love Tim's jokes. I wish he told them more often. I wish he told them every single day. All right? So could I have the next slide, please? Thanks. So the question is Tim's conduct harassment? And again, only rhetorical. The answer is maybe. So as I had mentioned at the outset, in order for the conduct to constitute unlawful harassment, it has to be unwelcome. But you're sitting there saying, wait a second, Jen. Jeff and Mark clearly welcome Tim's behavior. Jeff just said, I wish Tim told these jokes every day, right? He clearly welcomes his behavior. And Mark, well, he's laughing at these jokes, and he's telling them back, so he's got to welcome the behavior, right? Well, the answer's wrong. Not necessarily, right? So just because an employee participates in the offensive conduct, appears to enjoy the offensive conduct, or even reciprocates the offensive conduct, doesn't mean that the conduct is unwelcome. And how can that be? Well, put yourself in Mark's place, right? Tim's your supervisor, you've got Jeff there, you're all sitting around, and Tim's telling these jokes. He's your supervisor. He's the one who does your performance evaluations. He gives you the recommendations for your raises and the like. So Mark's thinking to himself, I think these jokes are disgusting. I find them offensive. But you know what? I'm concerned that Tim is going to take some kind of negative action against me if I don't laugh at the jokes. So I really want to be a part of this. So I'm actually going to tell them back. I really, really want to please Tim. So again, if Mark hits the 4 requirements of unlawful harassment, right? He thinks they're offensive, unwelcome, definitely on a protected characteristic. And in this case, creating a hostile work environment probably, because we know that Tim is telling the jokes every day, this is going to constitute harassment. So remember that this principle is not just limited to a subordinate supervisor situation. It can also be between coworkers as well. And you're saying, wait a second, how can that be? No, there's a coworker can't take an adverse employment action against another coworker. But again, put yourself in Mark's position. Maybe you're standing around the water cooler, you're in the break room, and it's all a group of your peers, and they're telling these filthy, disgusting jokes. You want to feel a part of things. You want to feel included, right? You don't want to be the stick in the mud. So you laugh at these jokes, and you actually feel like you have to tell the jokes back. So again, the conduct definitely could be unwelcome. So it can be in that coworker to coworker situation. So let's say, okay, you're going to investigate. You're going to go ahead and you're going to talk to Mark, right? And you find out Mark welcomes the behavior, right? It's okay. He doesn't unwelcome it. He welcomes it. He doesn't find it offensive. So it's not harassment. So you're saying, I dodged a bullet here. All right, well, Tim's a nice guy. I'm not really going to say anything. I don't have to say anything to Tim, right? Wrong. So think about this. So Tim is holding his meetings every week in his office. He leaves the door open. You've got Mark and Jeff there, right? And then who's got an office next door that shares a wall? You've got Sue, right? Sue hears these jokes every single week, right? She's tried to shut the door, but they're all loud talkers, so she has to hear these jokes every week. Sue finds these jokes offensive. She doesn't welcome them. And again, it is probably creating a hostile work environment because it's every week. So Sue is what we refer to as the unintended audience, right? So think about that when you hear these type of things coming in. So what do we need to do? We need to stop the behavior, right? We need to talk to Tim. Even though we've dodged a bullet, Sue hasn't complained, Mark hasn't complained, but let's cut it off at the pass. So this is why it's so important to stop what we say. It's not necessarily unlawful harassment, but let's try to stop the problematic behavior. So you want to stop the problematic behavior of Tim's disgusting and filthy joke telling in the workplace, right? So you bring him in and you counsel him and you say to him, okay, listen, Tim, you've got to knock this off. This is really offending people. And Tim says to you, but wait a second, does this mean I'm going to be fired if I tell another joke? And what do you say to him? Well, no, Tim, you just can't tell dirty jokes. You just can't tell offensive jokes. And what's he going to say back to you? Well, I didn't think they were offensive. Mark and Jeff didn't think they were offensive. How am I supposed to know? Here's what you tell him. You say, Tim, the next time you're telling a joke in the workplace, before you tell a joke in the workplace, I want you to run it through what I call the relative test. So, Tim, think about your last family gathering. You got all of your extended family there, whether it's a wedding or a family reunion. It's a big table, and you're all sitting around that big table, right? And you've got your 95-year-old grandmother on one end of the table, and you have your sweet little 5-year-old niece at the other end of the table. You've got all of your relatives in between, and I'm talking cousins and aunts and uncles. Tim, if you are comfortable telling that joke to every single person sitting at that table, then you're probably okay to tell it at the workplace. If you have to think twice and you think somebody may be uncomfortable or maybe not want to hear your joke, then let's save the joke and leave it out of the workplace and not tell your coworkers. So again, what are our key wrap-ups from this? Even though it appears that an employee is enjoying misconduct, participates in the misconduct, or even reciprocates the misconduct, they very well may not find it welcome, and thus, if it meets the other requirements, constitute harassment. Okay. Next slide, please. Thank you. Okay, so the next one is, and you're going to have to hear me talk for a little while. The next one is a dated claim brought to life. The current reporting of past events. Can you imagine where I thought of this one? Right, ripped from the headlines. What we're seeing is very stale claims brought to life. So here's how it goes. Again, you are an HR professional or are involved in the HR function. Randy, who's a current association employee, comes to you and tells you the following. He ran into Mary, who used to work at the association a couple of years ago. Mary tells Randy, well, she was still working at the association. One night, she and her coworker, another association employee, Joe, were working late. And they were sitting around talking, taking a break from their work. And Mary happened to mention she enjoyed salsa dancing. And Joe says, I love salsa dancing too. He grabs Mary out of her chair. He pulls her to him. He wraps his hands and places them on her rear end. He starts gyrating his hips and starts kissing her neck. Mary tells Randy, you know, it really upset me. I was so uncomfortable. I pushed him away. I said, don't ever do that again. But I was too scared and I didn't tell anybody. But I'm gone from the association, so, I'm telling you now. So again, Mary left the association over 2 years ago. She never said anything to anybody at the association while she was there. The association never has heard of this event at all. So in those 2 years since Mary has gone, Joe is a superstar, right? He's been promoted on up the ladder. He is the VP one of the VPs of the organization. And by the way, he just got married and his wife is just super adorable and really cute. And nobody has ever had a problem with Joe before. He's never had any performance issues. Nobody's ever made a complaint about him. Put up the next slide, please. So, does this require any action on your part? Shake your heads yes with me, please. Okay. And you're saying, wait a second, Jen. There's no liability here. Mary's not an employee. She's no longer protected by Title VII. Even if she got a bug in her ear and decided to file a harassment complaint against the association, what do we get to do? We get to say, this isn't a valid claim. It's past the 300-day statute of limitations. Mary, your claim is thrown out. There's no liability here. So, Jen, why do I have to investigate? Nobody's ever complained about Joe. Why do I have to do this? Well, we know you don't want to cause problems for Joe, but here's the problem. In the eyes of the law, right, if the association is going to be liable for harassment, doesn't take steps to investigate and stop the harassment or prevent its reoccurrence, right? It's the reoccurrence is that the real issue here. Once we learn about these complaints, we need to take steps to prevent the reoccurrence. So again, if the association doesn't investigate, you expose yourself to liability because what have you done? You have failed to take steps, you've failed to investigate, to take any prompt corrective action in order to stop the harassment or prevent its reoccurrence. So let's say I really like Joe. His wife is so super adorable. He's the VP, and I don't want to make any waves here. So you don't investigate. 6 months later, one of Joe's subordinates comes to you. She's crying hysterically. She tells you a very similar story that you heard about Mary. One night they were working late. Joe grabbed her, pushed her up against the wall, and starts to kiss her. Her name is Sue. Sue's going to bring a harassment claim against you, right? Right? She's going to file it with the EEOC, or if you're in the District of Columbia, she's going to go right to the courts maybe. And what's going to happen? We're going to have to disclose what? That we knew about the harassment and we didn't take any steps to stop its reoccurrence. And that's why we need to take action to investigate. So, and remember, with regard to the EEOC, because that's the first stop for most complainants, if they're not happy with the internal investigation, right, and the results. The EEOC's view is this. There is no valid claim of harassment if once you learn about the complaint, once you receive the complaint, if you respond promptly as soon as you find out about it, you take appropriate, effective remedial action, right, corrective action in accordance with your policies. We've all got those in the handbook. And then you take those steps that will stop the harassment or prevent its reoccurrence. So if you check all those boxes, you got a really great defense in the event you have a harassment complaint filed against you. So yes, we've determined you've got to investigate. So now you're saying, oh my gosh, are you telling me, Jen, I really have to call Mary? I have to call her? She hasn't been here for 2 years. This is terrible. The answer is probably yes, okay? And the reason, what do you say to Mary? You're going to call her up and say, Mary, you know, we learned about this incident that happened and we want to look into it. So can you tell us a little bit more about what happened with Joe? And so you're asking me now, I have to do this every single time? Every time I get an old complaint, I have to investigate? And the answer is yes, unless, and this is only an unless, there's an overriding reason not to do so. And this is where the balancing comes in. Because, you know, Todd and I know when we deal with this, you know, we understand that there's business implications that go along with these legal recommendations. So this is where your balancing comes in. Let's say Mary was a really big problem while she was at the association. She made a bunch of complaints, right? We know you guys were thrilled when she resigned and walked out that door and you got off without any issues. If Mary's that type of employee and we think that reaching out to her may incite her to maybe take some action, such as filing that EEOC charge, even though it's invalid, you're still left with the cost of defense, right? Or maybe she's going to get her lawyer to give you a call and say Mary needs some money because she was harassed while she was there. A reason like that may outweigh not reaching out to her. But it's got to be a really pretty compelling reason not to be reaching out to her. So you reach out to Mary, you get her side of the story. She confirms what Randy said, but she says, you know what, it's been 2 years. It's no big deal. I'm not really that upset about it anymore. I'm over it. Can you stop the investigation? No, you got to finish it. You have to talk to Joe. You have to get his side of the story, right? Part of your obligation is not only to respond promptly and investigate, but to make sure your investigation is thorough. And what do you need to do? You need to talk to Mary, the complainant, any witnesses that she identifies, and then you need to give the alleged harasser the opportunity to respond to the allegations. So we need to talk to Joe. So you want to interview Joe, you want to get the findings. So now you're saying, all right, this is ridiculous, Jennifer. I know that Joe's going to deny this completely. Why are we even going through this charade? Why would Joe admit that this happened? Okay, you're right. Okay, 99.9% of the time, he's going to say, I didn't do it. So you're saying to me, okay, well, I've got Mary who's got this story. She's given me no witnesses. And then I have Joe who's completely denying. He says he never worked late with Mary, that it's too late to look at time records and things like that. Those records are long gone. There's no documentary evidence. There's no witnesses that can corroborate either party's story, right? So what do I do, right? I mean, I hear this a lot. And so one thing you can take into account is the people's credibility, right? You want to take into account why did Mary not report it while she was still at the association when she was so upset? You also want to take into account Joe's story. Did he give you some compelling facts as to why it never happened, right? So look at it. And if you still can't decide, if it's still a 50-50, and there are going to be those types of cases, you need to still take some remedial action. But you're saying, wait a second, how can I take corrective action? Because I don't know if harassment occurred. Okay, let's not lose the opportunity to do something. Because if the harassment comes back and it comes to light, we want to make sure we've done it, at least done something, right? What can we do that's not going to be, some kind of disciplinary action toward Joe, but runs the middle of the line? Well, that's where you say, you call Todd or me and say, hey, you guys want to come do some harassment training for us, right? So bring somebody in, right? Have them train everybody. So you're not singling Joe out. You're reminding everybody, hey, this is what's prohibited. These are the reporting procedures. We take it seriously. And you can go ahead and remind them about their handbook and just redistribute the policy. So again, you are able to say at that point that even though you couldn't confirm that harassment did actually occur, you did take some corrective action to do so, to prevent the reoccurrence of harassment. So again, the wrap-ups from this, what are the key wrap-ups? If you hear about a complaint of harassment, even if it's stale, even if it's old, unless there is a strong overriding reason not to investigate, you need to follow through to avoid liability. All right, one more, guys. Next slide, please. Okay. So now we've got the next hypothetical is, please don't tell anybody a victim's request for confidentiality. I think we've probably all been in this situation before. So here are the facts. Again, you're an HR professional. The morning after the association holiday party, an employee, Vicky, comes to you, and she tells you she and Steve had a blast at the holiday party. They were drinking, they were doing shots, and they got a little drunk. Vicky parked a couple streets over from the hotel where the holiday party was being held, right? She said she's scared to walk to her car by herself, so she asked Steve to walk her to the car. Steve says, sure, not a problem. He walks her to her car. As she's opening her car door, he grabs her and starts to kiss her, right? She pushes him away and says, Steve, you need to stop. Vicky tells you, I don't want you to do anything. I just wanted you to know. I don't want to file a formal complaint. Please don't tell anybody. I know Steve was just drunk. He's a good guy. He didn't mean anything by it. And, Steve's got a wife. He's got these 2 adorable children. And I know that if his wife even gets wind that he was flirting with another woman, she's going to divorce him. And those 2 kids, they're going to be without a dad, right? What do you do? Can I have the next slide, please? Thanks. Okay, what do you need to do? Step 1, don't tell Vicky you won't do anything. Step 2, don't tell her you can keep this confidential, because you can't. Okay, and if you're the HR professional, step 3, you need to investigate it. Even though Vicky has begged you not to do so, she has asked you to keep it confidential, and she even said to you, this is the phrase, I don't want to file a formal complaint. Okay? And you're saying, wait a second, why do I have to investigate? Vicky's not going to sue. She just told me. She just said, she asked me to keep it confidential. She was just kind of keeping me informed, right? And Steve didn't mean anything by it. He was just drunk. It's not going to happen again, right? Well, here's why. In the eyes of the law, once an HR professional or any manager in the organization hears about the harassment, right? The association knows, right? You can't unknow it. And that, as soon as you learn about the complaint, remember the EEOC view that we talked about? You have to respond promptly and investigate. So you need to take these steps and prevent the reoccurrence. So again, remember the EEOC view is you get the claim of harassment, you promptly respond, you take the appropriate action, you stop it and prevent it from happening again. So you're going to have to go through and you're going to conduct the investigation. Go ahead, get all the details. If you need any more from Vicky, find out if there are any witnesses and talk to Steve, right? And you have to take appropriate action. In this case, maybe it's counseling Steve or some other issues. It depends on what you uncover, right? I do want to say a couple of words about what I hear, more than, sometimes frequently about the formal complaint. Sometimes I will hear, well, I didn't do anything about it because they told me I didn't want to file a formal complaint. And I will also see from time to time in the reporting procedures in an employer's anti-harassment policy that requires the complaining party to reduce the complaint to writing, right? So please understand that the formal complaint is a myth. No, regardless of how the association learns about the misconduct, whether it is in a passing conversation, whether an employee comes to your office and shuts the door, whether or not it's during work hours, or whether it's one of those, sometimes I've seen them, very, very long, detailed complaints that are written and submitted in writing. You know at that point, the association knows, and you have to take action, right, to stop it and prevent the reoccurrence. So again, don't require the employees to, if they come to complain to you, don't say, hey, can you put that in writing for me? You, as the intaking party, certainly should reduce it to writing, but don't say, I can't do anything about it until you put that in writing. And if it's in your policy, the requirement to have it in writing, that needs to be deleted. Okay, so another thing is I want to point out, again, my hypothetical was about an HR professional knowing, right? But this knowing applies to all managers and supervisors, remember? So it's really important that you train, and that's actually what I've been doing for the past 2 days, training the managers to understand that if an employee comes to him or her and tells them about the harassment and says, but you've been my mentor and you're my friend, please don't tell me, please don't tell anybody. Or they come to you and say, I'm only telling you because you're a man and I really want you to know this. Or you'll understand because you're a woman, but please don't do anything. Please keep this confidential. You need to train your managers that they can't promise confidentiality. They should not promise they're not going to report to HR and take any action. And you should also let them know that if an employee who's not under their supervision, maybe in another department, comes to them, the supervisor shouldn't say, oh, well, even though you told me this complaint, I'm not your supervisor, so I can't be the intake person for that. You need to go to your own supervisor. No, right? Again, once the manager knows, once the supervisor knows, the association knows. So whatever the reporting procedure is, whether the complaint goes to HR, tell your managers that, or if it's the COO, however your reporting procedures go within the company, so that individual or that department can go ahead and commence the investigation of the complaint. So again, what are the key wrap-ups from this particular hypothetical? Regardless of the manner or method by which you learn of an employee complaint or misconduct, you need to take action on it, regardless of the employee begging you to keep it confidential or not take any action, or even if they say they're not going to file a formal complaint. And I'm sure most of your policies contain in there that you will keep the complaint to the extent possible, because we all know that through the course of the investigation process that sometimes other people learn about it, sometimes the witnesses can kind of figure out, and the harasser by responding to the complainant's allegations as to who made the complaint. So again, we can't promise the employees complete confidentiality either. All right, with that, I'm going to turn it over to Todd.
Well, I learned something new and shocking. My 85-year-old mother is going to fail your dinner table test. Okay. Well, I am not a professional mind reader, not by a long shot, but I detect that most of you, if not all of you, have an EEO policy that is described as a zero-tolerance policy. I think we need to move forward 2 slides, please. Now, I also detect that your policy says something along the lines of the organization has a zero tolerance towards all forms of discrimination and harassment, which means that no incidents of harassment or discrimination will be tolerated. Am I right? Of course I'm right. Everyone has a zero tolerance policy, but what does that really mean? There are some words and phrases out there that really don't mean what people think they mean. They haven't really sat down and dissected it. So why do we have zero tolerance policies? Well, the easy answer is because people like them. They're very tidy. They don't require any math. There's no formula. There's no calculations. They don't panic when it's zero tolerance, and people don't like to panic. Now, on the other hand, when people hear they have to calculate whether conduct is harassing by measuring frequency and duration, and they panic, again, because they hate math. In its simplest form, however, think about it. Zero tolerance, in its absolute simplest form, means that if you engage in one act of harassment, you are fired, okay? One strike, you are out. Put up a Taylor Swift calendar, hit the bricks. Zero tolerance. Now, technically, that is zero tolerance. But if an organization were to interpret zero tolerance that way, it would create far more problems than it would solve. You would be setting the bar so low that on any particular week, you would have plenty of employees who will have engaged in words or actions that are perceived to have violated the policy. And if you set the bar that low, you're going to have folks who are going to be losing their jobs over certain types of conduct and others who are not for similar conduct, and then you're going to be faced with just a whole bunch of discrimination type claims, which you don't want. Okay? So I know what you're thinking. You're thinking, so under zero tolerance, it's not one strike. We have to give 2 strikes or 3 strikes or 8 strikes. Okay? That's not zero tolerance, Todd. You're making us do math. You said there was no math. Okay? I hear you. But I have a very user-friendly way to apply a zero tolerance policy with no math. Next slide, please. It's called ASMA. And I know what you're thinking. Asthma? Who names an HR tool asthma? What's wrong with you? Okay. Well, in fairness, when I first designed this, its name was gangrene. So I've actually done a little favor for you. You're welcome. So what is asthma? What does it mean? Okay, you can see it here on the slide. A, assessment, S, scale, M, movement, A, action, asthma. So how does it work? Start with A, assessment. Do you remember the very first slide we talked about? Okay. Assessment is, what are the facts? What happened? You investigate. Probably most of you as HR professionals have conducted some type of investigation. You interview witnesses. You review documents. You look at emails. You determine credibility. You filter out the labels and then figure out what are the facts. A, assessment. Step 2, S, scale. Remember I said you would hear about this again? My invention, the 1 to 10 scale. You're free to use it. You take the conduct and you put it on a scale of 1 to 10. Now, remember, there is no scale that's going to fit every organization. It is going to have to be designed for your culture, your size, your organization, your mission. Again, 1 is low, innocuous, 10, Kevin Spacey, okay? So you take the assessment of the conduct, put it on the 1 to 10 scale. Then you have to deal with M, movement, okay? What is movement? You may, but don't have to, move that dot either up or down the scale based upon the circumstances and context. And why would you do that? Well, think about it. If the person who has been accused of harassment is not the first time he's been in your office, okay, perhaps has been warned before, counseled before, threatened with termination before, in other words, a repeat offender, you are free to move the dot up the scale. Conversely, if this is a person who is a first-time offender, okay, they admit they did wrong. They are genuinely horrified and embarrassed about what they did, and they're completely contrite. You may, if you choose, move the dot back. You don't have to. These are discretionary calls, and there are 1,000 other circumstances that determine movement. What if, for example, the person accused of harassment is an extremely popular person who is very high performing and generates a lot of revenue for your organization? What do? You don't move the dot. Okay? There's going to be a huge temptation for people to say, move the dot. Okay? Go ahead and move it up. Go ahead. Don't do it. The courts don't acknowledge that as a factor that's relevant. And if you start moving the dot based on that, it is going to haunt you. It is going to create risks of discrimination claims. You're just not going to like it. Okay, so don't move the dot. Fourth is action, action. Action is deciding what action to take. And the goal is right there, to make it stop, to make sure it doesn't happen again. The EEOC takes the position that if an organization receives a complaint of harassment, looks into it, takes prompt remedial action, whatever that is, that results in it not happening again, the organization is not going to be liable, even if the harassment occurred. Think about that, okay? Now, this is not in all cases, but that's just the general big picture. But that's your goal, is to make sure it doesn't happen again, okay? So since zero tolerance, as we now know, doesn't mean termination in all cases, we need another 1 to 10 scale to make action work. This scale has a slightly different purpose. You once again consider your organization's culture, mission, environment, DNA. And then you, on that 1 to 10 scale, you overlay it with types of discipline available. So for example, 1 to 3 may be verbal coaching, counseling, training. 3 and 4 may be a written warning or reassignment. 5 to 7 may be a suspension or a demotion, a pay cut, loss of bonus, start stinging more. 5 and higher, 8 and higher could be termination. Okay? Some workplaces that I deal with, if it's above a 5, you're gone. Okay? Not zero tolerance, but they change the bar. How you have handled previous incidents, hopefully you don't have a large inventory of harassment allegations, that you have a well-populated scale, but how you've dealt with situations of the past will be helpful. If you've had a situation where someone has had a 6 and they're terminated and another 6 comes up and you don't terminate them, you're going to want to have a good reason. Because if you start treating folks differently for similar conduct, you invite another problem. But that's what zero tolerance means. It's not one strike, you're out. It means when you are confronted with conduct that violates your standards of conduct, you will take action that makes sure it doesn't happen again. So remember, asthma, okay? You'll breathe easy. I know. I debated it. Jennifer made me say it. Okay. Next slide. Do they need to know? Disclosures and liability. Okay, so picture this. You have a male employee, John Doe. He is accused of sexual harassment by 2 female coworkers. You find about this because the 2 women come into your office, and they're best friends. And they tell you that John is a predator. He's a horrible human being. And they're both very upset and very credible. And they tell you that he has, on separate occasions with them, pinned them against the wall and kissed them without permission. He has groped them. He has shown them pornography at work. And he has exposed himself to them. They both tell very similar stories. Now, you ask if there's any witnesses. They say no. So you have these 2 women employees with a very egregious story. So what do? Call John into your office, right? John comes in, and you say, well, John, we have to talk to you about something, and you You outline the allegations against him. And he goes, well, you know, I heard through the grapevine why you wanted to talk to me, and I took that opportunity to read the organization's EEO policy, and I understand it now. And, well, most of what they're saying is not true. I deny it, but I probably have done enough to get fired under your policy, so I'm going to quit. And he walks out. Okay. So you don't get to do the asthma analysis, but you're happy because he's out of there, right? Gave you a gift in a way. So a month later, you get, let me see, where are we? Okay, yeah, a month later you get a call from the executive director of XYZ Foundation. XYZ Foundation is a wonderful organization. They provide free in-home companionship services to single women who are recuperating from surgery and live by themselves. I mean, it's just a wonderful, wonderful outfit. The executive director tells you, oh yeah, we've got this applicant, John Doe. And we looked at his resume, and he says he used to work for you. And we interviewed him, and he seems like a fine gentleman, and says that he did well, and he quit. So how about a reference? Now, again, with my mind reader gift, I suspect that most of you have a neutral reference policy, right? You get a call, just the basics, dates of employment confirmed, job, possibly compensation. So, question is, do you follow the neutral reference policy and just say, yeah, John worked for us at these dates and this was his job? Or you spill the beans. You tell XYZ Corporation that this guy is a pervert and a predator, and he was almost ready to be terminated based on what he did. So what do? That question is too easy. I'm going to make it harder for you, okay? Let's make this hard. So let's say you choose path one. You say nothing. You give a neutral reference policy. John worked for us on these dates, this position. They hire him. John is assigned to an in-home companionship services. A month later, you find out that John has sexually assaulted one of the patients of XYZ Corporation. That patient finds out about John's past with you, finds out you were asked to disclose information about him, but you didn't. So that patient sues you for failing to disclose information that would have stopped her from being sexually harassed, or sexually assaulted in that case. Are you on the hook for that? Okay. Let's change it up just a little bit. Let's say, rather than providing a neutral reference policy, your neutral reference for John, you tell XY, you spill the beans. You say, well, John, he's a cad, okay? He didn't resign. He resigned in lieu of being fired. He was showing porno at work. He was groping women. He was kissing them without their permission. He was exposing himself. He's trash, okay? Do not hire this guy. He's a horrible human being. XYZ thanks you for your honesty, and of course they don't hire John and say, John, your former employer, told us some really interesting stuff about him, so just leave, don't come back, leave now. Now, John finds out you spilled the beans on him, so he sues you for defamation and interference with his employment relationship. Okay? In other words, you said things about him that caused him damage. And it turns out that the two women who complained about him had a bet between themselves to see if they could get John fired because they didn't really like him. And it turns, oh, wait a minute, so what about his confession? Remember, he confessed this? Well, remember, what he said? He said, well, I didn't do what they said, but I may have done enough to get fired under your policy. In his mind, he was thinking about the Taylor Swift calendar. Okay? That's all he did. So, are you liable to him for stating to a prospective employer false information that caused him not to get a job? Now, these two situations are purposely designed to be head scratchers. They're purposely designed to cause you to have to challenge your moral integument, okay? So what's the answer? You're not going to like this answer. I can tell right now. You all are upstanding, reasonable, kind folks. But I'm going to tell you like it is. The short answer is you follow your neutral reference policy, okay? In most cases, in 99% of the cases, as a former employer, you have no duty, you have no obligation to disclose facts surrounding why an employee left, even if those facts are horrible, even if the conduct is potentially criminal in some cases. You don't have that duty. And if you don't have that duty, you can't be liable if he, down the road, hurts, injures, abuses someone else. However, if you were to convey information about why he left your organization and he's not hired, and it turns out the information you disclosed is false, you can be liable for defamation, okay? And those cases happen a lot, and they can be very expensive. So the best practice is follow your neutral reference policy. Now, again, I knew you don't like the answer, but there is, in some cases, a middle ground. If you feel just so morally compelled to want to say something because you'll lose sleep, you just can't risk it because the potential behavior was so bad, you can tell XYZ Corp, we have a neutral reference policy. We're concerned about issues. If John signs an absolute ironclad release that allows us to say anything about him and he won't sue us, we'll be happy to tell you. Okay? Again, not something I recommend, but if you insist on doing it, I would have to say that. It does have a benefit because when XYZ Corporation says, what? they're going to wonder, and they may think, well, there's got to be something there and do their own investigation. And if John signs the right form, it does insulate you from a little bit of liability. So that's how you deal with external communications. Internally, it's a little bit different. So do you tell, after John walks out, do you tell current employees of your organization that John did these acts and was resigned in lieu of termination? It's a little bit of a different analysis because in the context of employment law, you all as an organization have a privilege under defamation law to communicate within your organization of folks who have a legitimate need to know information, even if that information is defamatory. And the reason is, the reason your folks may want to know is if they see him on the premises, they'll know to call security. Okay, so you have a reason that's not vindictive against John. But I would say that it should be bare bones, it should be 100% factual, and it should be limited to those who have a legitimate need to know. Perhaps the security office and perhaps senior managers and human resources. I think we have one more slide left.
All right, let's go back to Martha, the angry and accused supervisor. Okay, this is what's going on. So you have Martha. She is a white female. She supervises 2 employees. She supervises Sam, an African-American male, and she supervises Sarah, a white female. Both Sam and Sarah perform the same position. They both hold the title of coordinator. Sam comes to you and says he thinks Martha is harassing him because he's an African-American male. So you say, why do you think that, Sam? He tells you, Martha never really seems to want to talk to me all that much. She never wants to talk about what we do on the weekends. She doesn't really want to go out to lunch with me. And she reminds me that I have to follow the call-out procedures for when I'm sick. And you say, okay, thank you, Sam. Appreciate that. So you have to investigate, right? You have to look into this. So you talk to Sarah, right? And you say, and Sarah tells you, Martha doesn't socialize with her either. She's fine, you know, she talks to her, but they're not friends. They don't go out to lunch. And Martha reminds her that she's got to follow these call-out procedures as well. Okay? So what do we need to do? Next step, we need to talk to the person accused of the harassment, Martha. So you talk with Martha. Martha is shocked, right? And you can tell she's visibly shaken by the fact that Sam has lodged this complaint against her. It's come out of left field for her. She responds to Sam's allegations by saying, well, I'm here to work. I'm at work to work. I don't have time for chit-chat. I don't go out to lunch with anybody, right? I don't have time to socialize. And, you know, I have to remind Sam and Sarah about the call-out procedures because when they're sick, sometimes they forget to follow them. I'm just asking them to follow the procedures that are outlined in the handbook. So you look at the evidence and you say, okay, right, this is clearly not a case of harassment. You give your findings to Sam. You let Martha know. End of story, right? It's not. 3 months later, the association decides it's going to end a line of business, right? It's going to disengage from a line of business that it's been conducting. Who is responsible for this line of business? Sam and Sarah. You talk to Martha, and Martha says, well, we need to terminate Sam. There's only one coordinator position left, and it's going to be Sam, not Sarah, right? And you go ahead and you think to yourself, wait a second, Sam just made a complaint not too long ago, and now we're going to terminate him. Could this be considered retaliation? Next slide, please. So in accordance with the law, your harassment policy says and prohibits managers and supervisors from taking any adverse employment action against any employee who what? Makes a complaint of harassment or participates in the investigation process or otherwise opposes discriminatory practices in the workplace, right? It's there. So if you terminate Sam, does Sam have a valid claim of retaliation? Maybe. Okay. So what I want you to remember is we've got the harassment claim bucket over here, right? And we've got the retaliation claim bucket over here, right? They're two separate claims. So we've determined that there was no harassment, and we're comfortable that we're going to be able to defend that successfully, right? Even if Sam brings a complaint of harassment. But now we have to deal with a potential retaliation claim. So 3 elements for a successful retaliation claim. The first is the employee has to engage in what is called a protected activity. So if an employee makes a complaint of harassment either to you, the organization, with the EEOC, or in the court, that is all considered protected activity. It is still protected activity even if you investigate the complaint and internally determine that no harassment occurred. So what I'm trying to say is it's protected activity regardless of whether Sam's complaint was founded or unfounded. It still meets the element of protected activity. The second element of retaliation is an adverse employment action. We all know clearly that termination is going to be an adverse employment action. And what else does there have to be? The third one is there has to be a connection between the protected activity and between the termination, right? It has to be you engage in the adverse employment action because of the protected activity. And I will tell you, the courts find very compelling when you have a protected activity, a complaint that's very close to the adverse employment action. We call it close proximity, right? It happened close together in time. It's very strong evidence, quite frankly, that there is retaliation. So in the instant case, right, we've got Sam. He made the complaint. It's unfounded. He made it in good faith, right? But it's an unfounded complaint. So there was no harassment, but he did make that complaint. So it's still a protected activity. We're going to fire him. And, you know, it's very close. It's only happened, the two events happened very close in time, only 3 months apart. So you're scratching your heads and you're saying, wait a second. So you're telling me we can't fire Sam? Well, here's the answer. You need to kind of give it the pressure test a little bit before you actually go through with the termination. So you can engage in and terminate Sam. And even if he does meet those elements of retaliation, you've got the defense. And what's your defense? You have a legitimate business reason for terminating him that has nothing to do with the fact that he engaged in that protected activity. So you're saying, okay, well, that's clear, Jennifer. You just told me, we're eliminating this line of business. There's only going to be one job left. And that's why we're eliminating Sam's position. But what did I tell you? We chose one employee over another, right? We chose Sarah to stay in the coordinator position, and we chose to eliminate Sam. So we need to kind of take the next step and look into, does it make sense? Is there a legitimate business reason to terminate Sam rather than Sarah? How do we do that? We look at the documents. Let's look at the performance evaluations, right? Let's look to see who's been at the association the longest, who has the wide range of skills that's needed to perform that coordinator position. Is there a legitimate business reason for actually keeping Sarah and terminating Sam? If the answer is yes, then you have a good defense, right, to a claim of retaliation. But let's say you look at the data and you find out that actually Sam has been getting 5s out of 5s on his performance evaluations, and he's been at the association for 5 years. Sarah just started about a year ago, and she's gotten 2s out of 5s on her last evaluation, right? So what do you need to do then? We need to look at Martha, and we need to actually investigate her for potential retaliation. And in that case, the data doesn't support Sam's termination. And so you're not going to have that good defense, right? So in that case, you would want to terminate Sarah instead of Sam. So again, the elements to retaliation are the protected activity, right? And you've got the adverse employment action, you've got the causal connection. Even if you meet those requirements, you can still have a legitimate business reason for engaging in the adverse employment action. That's your defense. But really, train your managers about retaliation. I think it's really difficult. I mean, we're all human beings, and when you're shocked and surprised, it comes out of left field that you've got this employee complaining about you because of harassment. They also need to understand that not only should they not engage in adverse employment actions, and that's like, right, that's termination, right? We know that one. Maybe not giving a raise is another adverse employment action, taking away maybe certain supervisory duties and the like, but they should also think about other behaviors to avoid that may be interpreted as being retaliatory. And what am I talking about? After the complaint's been filed, all of a sudden, Martha really stops talking to Sam. She gives him the cold shoulder. She doesn't spend as much time with him, right? Even though those are not going to be considered what the law views as adverse employment actions, what that's going to do is instigate Sam to feel like he's being retaliated against, and then you've got the issue that starts all over again that you have to investigate there. So I tell my clients, you kind of just got to grit your teeth and smile, right? And go forward. And that's what you're going to have to tell Martha and those supervisors who have been accused of harassment, which you ultimately find to be unfounded. And with that is the end of our hypotheticals. And I think we're going to move to, I'm going to turn it over to Cindy.
Right. We are going to move to questions. And I thought those were great hypotheticals and really brought out a lot of the real life practical on the ground issues as promised. I will take questions in the room. We've also been collecting questions from online, and I have to laugh at them because they've been coming in since early in the presentation. And the first one, Todd, you say you're a mind reader. The first one was, what do I do when I'm asked for a reference check? How can I withhold this information? So I think you got to that. That came in, probably 10 minutes into the presentation. So yes, good mind reading. The next one I'm going to take from here, I have so many questions here that touch on it that I have to assume people are asking it here too, is, so I've got an employee sexual harassment policy. I know how to handle it with my employees. What do I do with my board members? What do I do with my volunteers? What do I do with my members, at the member conventions when members are harassing other members? What is my responsibility? So they're not employees, they're volunteers, board members, members. Over to you guys.
Okay, this is one we get a lot.
Did anybody else have that question? Yeah. Donors too.
Okay.
Right. I've seen that.
So first of all, let's talk about your employees. And so maybe board members harassing your employees or other people at conferences. So just remember and remind your employees as you're doing the training and the like that harassment is prohibited from third parties as well. So if an employee is a victim of harassment from a third party, like a board member or like a donor, they need to report it. And also, when we talk about the workplace, it's not just the four walls of your offices. It's anywhere where your association is conducting business. So the harassment is going to apply there as well. So with regard to board members and your volunteers, it gets tricky. And I mean, quite frankly, we've had an uptick in requests for this. Now, they're generally not going to be regarded as employees under Title VII. So it doesn't apply in the same way. However, we've already talked about employees, so we're just talking about volunteers and talking about the behaviors in which they engage. We want to make clear that they're not entitled to the protections, but we do want to communicate to them that the same expectations apply, and we're going to prohibit the same types of behavior from them. Any more?
No, you nailed it.
Okay, let's take a question in the room. Okay, thank you. Yeah, there's a mic over there, and for people on this side, Camille will bring you a mic.
Could the panel speak a little bit about the need to maintain confidentiality by the accuser during the process, and even once a decision is made? What degree of confidentiality must be maintained, and what happens if there's an infraction?
That's you.
Okay, I think I'm on now. Great question. So you want to make sure, we have in our policy, okay, we're going to keep it to the greatest extent. We're going to keep it confidential to the greatest extent possible, and we'll do everything we can. I talked a little bit about why we can't always keep it completely confidential. That's a great question. The confidentiality duty applies to everybody involved. So that includes the supervisor to whom the complaint was made, everybody in HR, it includes the complaining party, and it includes the harasser. You need to communicate to your employees through the course of your training that this confidentiality obligation you take very, very seriously. And if you violate your confidentiality obligation, that you will be subject to discipline.
Okay, Todd, I have a question for you from people online, and it is, should the term zero tolerance just be removed from our policies completely?
No. Zero tolerance is important because it has a deterrent effect on your workforce. Even though you don't have a one-strike policy, there's nothing wrong with letting folks think you do. It kind of helps them toe the line and behave. So that's really the huge benefit of it. So keep it.
Okay, another question in the room?
I'd like to add to that, today is not the day to take that out of your policy. We're moving away from zero tolerance. My question, I have a follow-up question on the donor. What if you have, say, a high wealth donor and has hit on some of your female employees? Is it acceptable if you decide it's not bad enough, you'll continue to engage with that donor? Is it acceptable to only put men in front of that donor, or are you just encouraging the conduct? And if it's not acceptable, what do you do?
That's a great hypothetical. I like it. So yeah, I mean, I think again, you need to protect your employees, so you need to take steps to prevent its reoccurrence. So I think in that instance, you need to talk to your donor. What I would recommend, rather than putting only men in front of the donor, if it has been sexual harassment aimed only primarily at women, you want to make sure that the meetings and the interactions are with other people, right? So they're not just one-on-one. And you want to go ahead and instruct that donor to the extent you can. I know it becomes very touchy, probably even more touchy with donors than it does with board members, so I can appreciate that. But you want to make sure they're involved in the a third party's CC'd, maybe on email communications between the parties and the like. But I would recommend just making sure that you have somebody there to act as a witness to deter the behavior. Anything else? Does that help? Okay.
Additional questions? I am smiling because I see these questions here. It's like they've preceded their, what if the person is already gone? Do we still have to investigate? What if all these questions are questions, you really covered what people were thinking.
We knew that they would be coming.
I just want to follow up on the issue about confidentiality. When I think you stated that we need to make sure that both the plaintiff or complainant or the recipient of the complaint understands clearly that the expectation is that things will remain confidential. The follow-up question is, if that's interpreted as if they cannot discuss this with anyone, can that they can interpret it as suggesting that they cannot go outside of the organization and share what happened with someone outside of the organization. Should that be made clear as you're describing what the expectation of confidentiality should be?
I think the answer is, what you want to say is you want to keep it confidential and not discuss it with your coworkers, right? Other people in the workplace. I don't think that I would suggest making it clear and expressly stating, by the way, you can go talk to your attorney about it, because we don't want to raise any red flags, right? But I think if you make clear, don't talk about it to anybody in the workplace, that's the obligation.
Confidentiality is like this horrible iceberg, because it sounds like the top is easy to just make that conveyance, but in practice it's got this underbelly which is very risky. Because think about it, you have the admonition of confidentiality to the person who's complaining and perhaps the witnesses, and let's say they ignore you and they start talking about it. Are you going to go ahead and fire someone who complained about sex harassment, has a valid claim, but then talked about it? You're really setting yourself up for a difficult case, because they could easily say, well, you're retaliating against me by making me keep this confidential where the law permits me to do it. So if they're not being disruptive, if they're not overtly lying, in many respects, it's kind of a toothless direction. So don't get caught into that cycle of thinking because they disobeyed the request for confidentiality, they violated our standards of behavior and we're going to punish them, because that is going to be a lot worse. Sometimes you just have to accept it and work through it.
Here's a related question to confidentiality. It relates to what you were saying, that if someone comes forward and tells a manager or supervisor that that there's a sexual harassment issue, the organization's on notice, that manager or supervisor can't keep it confidential. But what do you do if you have a manager or supervisor who comes forward and says there's a problem, that somebody came to him or her but won't say who it was and says they promised to keep it confidential? What do you do with that manager or supervisor?
You take them into the back room, show them what I call the rubber hose, and let them know that it is their obligation as a manager, supervisor of the organization, as an arm of the organization, to share this. That is not their decision to keep it confidential, and it is a condition of employment to spill the beans, and you need to exert pressure to get the information.
I thought that's what you were going to say. Question over there.
I think you answered that, but related to that, if a case gets to the EEOC level, the deposition level, can you compel an employee with the threat of termination to give a deposition?
Fortunately, I've never had to do that. And I would say no, you couldn't, because that person could very easily say, I have the right to speak or not to speak. Now, technically, you could subpoena them, and the court compels them to answer questions, so the court's doing your dirty work. But I would go through the formal processes. And a similar question that you haven't asked is, what if you have an employee who gives a deposition and lies about the sex, or, say they're a witness, and they totally make something up about the incident, and you know it didn't happen? Can you punish them? No. The courts are clear that if someone is participating in a government investigation, in particular is litigation, they have an absolute privilege to say anything they want, even if it's a lie, and you can't punish them for it. So how about them apples?
Wow. So going back to the reference check issue, aren't there state laws in some states that allow people to that protect organizations, the truth in reference statutes?
Semi. It's a qualified privilege. And qualified privilege is different than the absolute privilege that allows that person to lie at the deposition. It gives you the you can provide information about someone if you have a good faith basis for it being true and you can't be sued. But it doesn't mean you won't be sued. It just means that the bar of proving you're liable is harder. You still have to pay your lawyer to defend you. You still have to have resources devoted to it. So it's
You're just, life is a bowl of cherries, Todd.
here to serve.
Other questions in the room? Back there, please.
What information can you give the accuser about what will happen to the harasser?
We all hear that personnel matters are confidential.
That is, yeah. I mean, and that's a tough question. I mean, because, right, personnel matters are confidential, so we can't disclose to the complainant, exactly the remedial action that is being taken against the accused harasser. We don't want to say, oh, don't worry, we wrote him or her up. But I think what you can do is just kind of restate what we've talked about today, which is, listen, we've taken, appropriate action here. And, if you have any additional concerns or if it happens again, please come to us.
Okay, last question.
Hi, what is your view on HR hotlines where you can, like a number so that they can make complaints without disclosing their identity? I find them very difficult to investigate, but I know there's a lot of other guidance that they're a good practice.
I actually agree with you. I'll let Todd weigh in. I've had similar difficult, problems with the investigation process. I think it's a good idea in the sense that you want the employees to, to report the harassment so you can create that environment that's free of harassment. But at the same time, it does give them the opportunity just to drop and then run. And so the only thing you can do as an organization is to go back to the hotline. And what I've done is try to get the complaining party to give more information. And then you can, that's about the only way you can do it.
Yeah, if you are a typical centralized one location organization, you don't need it. They usually are situations where the workforce is dispersed and you may have locations without HR presence or without a qualified supervisor, and therefore they have nowhere to go. So you give them an outlet that's not otherwise available. But if you have multiple avenues for your folks to use at all times, that's sufficient.
Well, with that, I want to thank everybody for coming, and please join me in thanking our wonderful panelists, Jennifer and Todd.